very seriously what we said in our petition, namely that there were grand jury leaks, and if the grand jury's office participated in it, it should result in a dismissal of the charges. That's what I got out of that. Nothing that strong. I was expecting that we could get some success, but I must confess I was surprised at the judge. I found out about it this morning about 5 a.m. Absolutely. What was I take it, and listen, I just got the emails. I didn't get a press release. And the emails showed some contact from the supervising grand jury judge, which appeared to be very bad, very prejudicial against Mr. Sandusky and others. And it was very serious. I didn't get her statement. No, I just saw the email. I'm thrilled.
In your own words, for the ladies, what issue was raised by these statements? What's the difference?
All right, there was a grand jury investigation. It's our position that there were leaks by the Attorney General, and they were done deliberately, or at least there's some evidence that they were done deliberately, and it was an abuse of the grand jury secrecy to further an investigation. There is that. And in addition to that, as part of what we said in our petition, that the judge, the grand jury judge, reviewed everything that we asked for documents for what they call Brady material. Brady material is material that is useful to the defense. The judge ruled that there was no Brady material. And what this judge was saying is that these emails showed, this emails that came in last night or yesterday, show this bias of the judge. Doesn't that color this judge's review of what that judge did with reviewing Brady material? Is that in enough layman's terms?
Well, how about this? Why don't you tell us your take on what the judge is telling us to do, and what is he ordered to do?
I think he's saying put up or shut up. In other words, you're saying that these things were there. I want to hear it. I want to hear exactly what you're referring to. And if they are what you say they are, we're hoping that there'll be a dismissal of this case.
He's now wandering into reversible territory now.
What?
He's now wandering into reversible territory. These things that Ms. Kane brought up, Attorney General Kane brought up, are true and they're clarified. This would be very good for your particular view.
Yes, we're indismissible. What did you call it? Wandering into?
Reversible.
Our whole PCRA petition is into this area of reversible error. We think there are many, many grounds to reverse this conviction.
Just wipe out the testimony.
Wipe it out? The answer is it would be a dismissal of the charges, whatever that would mean. The answer is, would that negate the effect of this testimony? Sure. Because there was potential grand jury abuse. It's more than leaks. Well, what they said is that there was this judge showed in these emails that he had a bias, number one. And Kathleen Kane, apparently, and I didn't see her press release, but in her press release, whatever she released to the press, indicated that there was things that occurred improperly. In a prior press release, Mr. Scofaro did a story wherein she said that she was highly suspicious that that office, the Attorney General's office, had leaked the information we were complaining about. It's the law.
So just if
I don't know, but I'm going to say he's a free man.
But there would be no second cause.
I think that that's what should occur. If there is this type of prosecutorial abuse, you betcha.
So then if there was this possible abuse, then you're not believing anything that the victim said on stand and victim that the victim said was lying.
It doesn't mean anything other than that there's a dismissal of the case.
So in terms of their testimony and what they actually said happened, then is there contention that they all lied about that?
It's not our contention anything other than that there was an allegation of prosecutorial abuse. And when there's prosecutorial abuse, the remedy is to dismiss the charges. It doesn't have anything to do with the credibility of the witness.
Explain the subpoena that you're, the power that you're looking for, what you say for.
What we said, we were looking for one witness who was victim number 2, who we say that the prosecutor said in his closing argument, they didn't know who he was when they knew very well who he was, and that this witness, victim number 2, had very damaging information towards the whole case, because this particular witness called into question the credibility of the testimony of Michael McQuarrie, which is what we said. The testimony of Michael McQuarrie is the Christmas tree upon which all the ornaments were hung in this case.
So if you got that subpoena power, you're looking for fee agreements, like financial payoffs for these people? Is that-
I'm looking for fee agreements with lawyers. These witnesses testified that they signed something, but they don't remember what it was. They don't know what it was, but they had lawyers for the purpose of dealing with the media or helping them through this ordeal. Our position is they signed contingent fee agreements. It was obvious that that's what it was, and they eventually got money from Penn State. What? I want to talk to him. What? Who? Mr. Sandusky. Mr. Sandusky has been subjected to solitary confinement for about 3 years. It's horrible treatment in the prison. He's a level 2 prisoner that's being treated with level 5 security. It's just awful. How's that? What? I'm afraid I gotta go here. Anything? All right.